The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning. Welcome to the North Carolina Court of Appeals. My name is Judge Chris Dillon, and joining me on the panel today are Judge Hunter Murphy and Judge John Arrowwood. Right now we have the second case on the morning calendar is Ferrera versus Robbins. And we will first hear from the appellant, Mr. Steinberg, and if you're ready to proceed, that's fine. I understand you want 5 minutes rebuttal. Is that correct?
Yes, Your Honor.
Okay, you can proceed.
Thank you. May it please the court, my name is Ben Van Steinberg, and I represent the appellant, Christian Ferrera, who's the executor and administrator of the estate of Yesenia Funes. My client respectfully requests that this court reverse the trial court's decision and hold that my client did properly plead gross negligence, such that the qualified immunity provided by NC Gen Stat 122C-201.1 is overcome and allow my client to have his day in court. I'd like to briefly summarize the facts. As I said, I represent the estate of Mrs. Yesenia Funes, who was horrifically murdered by her son Oliver Funes while he was in the midst of a psychotic break. Oliver was brought to UNC Wakebrook, which is a psychiatric facility, on January the 17th, 2017. The UNC Wakebrook intake staff determined that Oliver should be involuntarily committed for both his safety and for the safety of others. The defendant, Dr. Robbins, followed Oliver during his month-and-a-half-long involuntary commitment, and then Dr. Robbins released Oliver from UNC Wakebrook on February the 28th, 2017, despite having adjusted Oliver's psychiatric medication only 4 days earlier. And further, Oliver's medical records show that UNC Wakebrook staff had observed him noticeably responding to hallucinations on the very day that Dr. Robbins released him. Also, Dr. Robbins did not give Oliver any long-acting antipsychotics that would have regulated his mental state. Instead, Oliver returned home without any follow-up from Dr. Robbins or the UNC Wakebrook staff. Less than a week after Oliver was released from UNC Wakebrook by Dr. Robbins, he tragically murdered his mother by stabbing her and cutting her head off in front of his two younger siblings. The plaintiff, Mrs. Funes's brother-in-law and the administrator of her estate, filed a complaint against Dr. Robbins in Durham County on February the 28th, 2019. Plaintiff also filed a claim against UNC health entities and the Industrial Commission on March the 1st, 2019. Plaintiff attempted to serve Dr. Robbins by certified mail, but prior to effectuating service, plaintiff's counsel was contacted by counsel for Dr. Robbins. Dr. Robbins' counsel agreed to accept service for his client, and plaintiff's counsel mailed an acceptance of service to be signed to Dr. Robbins' counsel along with a copy of the filed complaint. Now, it appears that the version of the complaint that was sent to Dr. Robbins' counsel may have inadvertently omitted page 19. And now page 19 happens to be the page of the complaint that contains paragraphs 141 through 145, which is where plaintiff's allegations of gross negligence are found. Dr. Robinson's counsel filed the signed acceptance of service on March the 14th of 2019, and then Dr. Robbins filed an answer and an amended answer that both contained a motion to dismiss pursuant to Rule 12b-6 based on statutory immunity provided by NC Gen Stat 122C-210.1. And after hearing on November the 13th, 2019, the trial court granted Dr. Robbins' motion and signed an order dismissing plaintiff's complaint pursuant to NC Gen Stat 122C-210.1. Now, the issue before the court is whether the plaintiff properly pled gross negligence such that the statutory immunity provided Dr. Robbins by NC Gen Stat 122C-210.1 was overcome.
Well, you have a negligence claim and a gross negligence claim. Is that correct?
Yes, yep. That's correct, Your Honor.
And they were both dismissed. Is that correct?
Yes, Your Honor.
Okay, and you're talking first, I guess, about the gross negligence. I get to show gross negligence. You have to show, is it willful and wanton? Is that correct?
That's correct, Your Honor.
Okay, point to me in your complaint where you've alleged that any negligence by Dr. Robbins was willful and wanton, or where we can infer that, I guess.
Your Honor, that would be in paragraphs 145 on page 19 of the filed complaint, which is, I believe, in the record on page 21. And paragraph 141 through 145 is under the second claim for relief for gross negligence against Brian Robbins, MD, and the starting on paragraph 142 reads, defendant Brian Robbins, MD, was grossly negligent in that he, and then the complaint enumerates 5 different gross, willful, and or wanton actions by Dr. Robbins, and also in subparagraph L of paragraph 142 leaves open the possibility that further grossly negligent conduct may become clear and develop through discovery, which is, Your Honor, I believe important to note because to survive a 12B6 motion, the plaintiff should only have to put the defendant on notice pursuant to notice pleading of what's actually being complained, but that does not preclude further development through discovery of any, in this case, grossly negligent actions or omissions by the defendant.
Okay.
And the question before this court when conducting a de novo review, as is appropriate for a 12B6 dismissal review, is whether, as a matter of law, the allegations of the complaint treated as true are sufficient to state a claim upon which relief may be granted under some legal theory, and that whether properly labeled or not. And that's from this court's opinion in Leary v. NC Forest Products, Inc.
Well, you're not arguing that the wrongful death claim was improperly dismissed, are you? Only the gross negligence claim.
Your Honor, I would contend that both the ordinary negligence and gross negligence claims should survive the 12.
Well, how do you get past the issue of privilege or the qualified issue with respect to that you have to have gross negligence in order to have a claim?
Well, Your Honor, I believe that the Brilliolette opinion speaks to that issue, and the Brilliolette opinion says that you cannot plead only gross negligence, but my understanding is that in light of that you can plead ordinary negligence in addition to gross negligence and have that ordinary negligence claim survive.
But you can't prevail on an ordinary negligence claim, can you?
Not on its own, Your Honor, but
you have to show gross negligence in order to be able to prevail against this defendant. Isn't that correct?
That's correct, Your Honor.
I think if I understand your question correctly, because I think this is where I had a little bit of confusion between the briefs. Is it your position that if you show gross negligence, then you can also recover for regular negligence and wrongful death if the jury finds gross negligence, versus if the jury, if the jury does not find gross negligence, whatever they find on regular negligence or in wrongful death is out the window anyways because it's protected by the immunity. Is that kind of the nuts and bolts of the argument, or am I mischaracterizing that?
Your Honor, I think practically that's how it would proceed. I think that it's not that it would have, that had we only pled gross negligence and not pled any ordinary negligence, that would have been sufficient to certainly to survive 12b-6. But I don't read the case law as saying that that the ordinary negligence can't survive in addition to the gross negligence, only that the ordinary negligence can't survive if it's pled on its own without the gross negligence allegations.
And is that language in that case, is that part of the holding, or was that just merely dicta?
Your Honor, I believe it's part of the holding, and the actual language of the holding is that the ordinary negligence claim, I don't have the exact language in front of me, but I believe it says that the ordinary negligence claim cannot survive on its own, which I think is crucial to the holding of that case. But I believe that that the logical inference from that is that, or the logical inference is not that a ordinary negligence claim cannot survive on its own, or cannot survive in addition to the gross negligence claim, but only what is said in the opinion, which is that the ordinary negligence claim cannot survive on its own.
What I understood the law to be was you could sue for ordinary negligence if the defendant couldn't prove that they didn't follow the requisite procedure or exercise professional judgment. That's the way I mean, am I misreading it?
Your Honor, I think there was some confusion, which is why the statute was amended in 2019, because the statute did read if they did not follow accepted judgment practice and standards, that they could not avail themselves of the immunity. However, when that was the case, the statute read that way from 95 to 2018,
right?
And the Brilliolette case was a 2009 case, and the Snyder case is a 2007 case, and they both say that you have to plead gross negligence to survive the immunity. So I think that reading between the lines, I believe that the legislature intended that consequence, and they modified the statute in 2018.
So you can no longer sue for just ordinary negligence on its own at all.
Your Honor, Your Honor, I believe that pursuant to the Brilliolette case that you could not sue on ordinary negligence alone prior to the amendment to the statute in 2019.
I'm looking at the Brilliolette case. I'm at page it's 5, looks like 540 to 541, which is the last two paragraphs. States, accordingly, we hold that the failure to obtain a second employee's signature, not a departure, to use and follow the requisite professional judgment practice and standards so as to prevent attachment of qualified immunity pursuant to the North Carolina General Statutes 122C 210.1. So if this case is only holding that the immunity came in to prevent, or that the immunity was applicable to these facts, does any of the other language of Brilliolette matter in terms of our consideration of what is and isn't a valid pleading?
Your Honor, I read that part of the holding as applying to an ordinary negligence allegation. I think when you look at the complaint that was actually filed in Brilliolette, it's clear that there was no specific gross negligence allegation, which is contrary to how the complaint in this case was pled, as well as in the Snyder case, which both have distinct gross negligence allegations. So I think that that's I would agree, Your Honor, that if a complaint only has a ordinary negligence application or ordinary negligence pleadings, then that is how that paragraph would apply.
And that's based on our past interpretations of the statute, nothing specific in the applicable statutory language that says you have to have gross negligence, or is there part of the statute that I'm missing there? It's our
Your Honor,
application and past cases of what the case says.
that's correct, Your Honor. As the statute was in effect and at the time of the facts of this case, then that would be accurate, because it was not until October of 2019 that the statute was modified to remove the professional judgment practice and standards language and replace it with grossly negligent.
And I want to go back to what Judge Dillon was asking about a little bit regarding record page 21. You pointed us to paragraph 142 in your complaint, I believe it is, and 142, and then you got subparagraphs G through L there. You have grossly negligent in that he, and then list all these things. In your brief, you argue that, these actions in and of themselves suggest that they're willful or wanton. Is that a permissible inference in reviewing the pleading without those, I'll just use the word magic words. Is that an inference that has to be more specific here? What allows us to make the inference and read willful and wanton into these subparagraphs in their actions? Because I think, they could be willful or wanton, or they could, potentially just be negligent. So talk to me a little bit more about the pleading requirements, even under the, liberal rules, or construing them liberally.
Your Honor, as this court said in the Acosta v. Byram case, that, as Your Honor pointed out, the complaints must be liberally construed, but also that notice pleadings that need not contain detailed factual allegations to raise issues. And again, at this point, being at the 12b6 posture rather than at summary judgment, I would say, Your Honor, that the fact that they could be willful and wanton is sufficient to survive a 12b6 failure to state a claim, and that at the very least, discovery should be allowed to develop those pleadings and the facts that have been pled, and determine whether there was actually a willful or wanton actions on the part of the defendant.
Is gross negligence defined in our case law or our statute anywhere?
Your Honor, it is, and I believe actually the defendant cites it in his brief.
What's it defined as?
Your Honor, it's defined conduct done with conscious or reckless disregard for the rights and safety of others. And that's from the Toomer v. Garrett case, 2010 Court of Appeals case, 2002 Court of Appeals case, sorry.
Well, and you alleged a bunch of negligent actions. Have you alleged that these negligent actions were done with reckless disregard? You have to make that specific allegation, or have you done so?
Your Honor, I would argue that we have done so. For example, I discussed the note in Mr. Funes's Oliver's record that show he was responding to hallucinations, and that is certainly something that should have raised Dr. Robbins, should have raised his attention if he was following the accepted judgment practice and standards, and that there's only one of two possible outcomes: that either he did read that note and he willfully ignored it, or that he didn't read the note and wantonly released Oliver to his family without having adequately determined whether it was safe to do so. And so I believe that Your Honor supports the gross negligence allegation as it's read in paragraph 142 of the plaintiff's complaint.
Well, I mean, I think it's one thing to say that he didn't know there was a note there, or didn't whatever, and just didn't look. That seems to me negligence. But if he knew it was there, or read the note and just said, "I'm just going to disregard it," that would be the gross negligence. I'm just trying to. I mean, I'm just trying to see where you've alleged that. You say he failed to recognize that Oliver was at. Is that because he was negligent and just not looking for a note, or he knew there's a note there, but I'm just not going to look at it? That to me would be more like akin to gross negligence. I mean, I'm trying to figure out what the difference between negligence and gross negligence is.
Your Honor, Alex, I think it goes to the not just a violation of a duty to act reasonably, but to the willful and wantonness, as the case law says. And I believe it can either be willful or wanton. And I think that, in looking at that record situation, that it's either willful to read it and to ignore it, and it's wanton if you don't read it and you release a potentially dangerous individual into the community. And again, perhaps those would need to be developed a little more to survive a summary judgment motion. But again, all inferences being made in the favor of the non-moving party at the 12B6 level, based on purely what's contained in the pleadings, that should be sufficient to survive that 12B6 motion.
Now, I have a question here. This is at 12B6 stage, is that correct?
That's correct, Your Honor.
And you have alleged that in paragraphs 142G through L, that all of those actions are grossly negligent. Is that correct?
That's correct, Your Honor.
And by alleging they're grossly negligent, does that mean under the Toomer case that you've alleged that they're wanton conduct done with conscious or reckless disregard of the rights and safety of others?
Yes, Your Honor. And I believe it was borne out because Oliver did actually cause that reasonably foreseeable harm to rather Dr. Robbins' decision to release Oliver caused that reasonably foreseeable harm, and that was not just negligent but willful and or wanton in doing so.
And
So it just comes down to whether or not you pled gross negligence or not. Is basically what this appeal is about, it seems to me.
Yes, Your Honor.
Let me ask a follow-up, really based on what Dylan just said regarding our scope of review. On 12B6, they kind of broke their 12B6 argument up into two parts, and only got a ruling on this issue with the immunity. Does that limit our scope of review to only this part of a 12B6, or is this more akin to other cases where we review 12B6 as a whole, and if there's a reason to kick the complaint on its face, we should be kicking the complaint on its face?
Your Honor, I would say that the issue before this court is the one that the trial court ruled on, and the trial court made clear that it was ruling on the immunity issue. And I know that the defendant has raised a failure to warn issue about whether that pleading is appropriate and sufficient. But Your Honor, I would say that the court did not rule on that issue, and therefore it's not properly before this court. But that even if it was, that the failure to warn issue is one that in this circumstance, I believe that this court should recognize a failure to warn obligation.
And I see, on your reply brief, page 2, you indicate, it's not properly before this court in your header there. But then I don't see any citations to any cases to suggest it's not properly before us. When we are reviewing an order from a 12B6 motion, are there any cases that you can point us to that suggest when you have a divided 12B6 motion like this and the trial court only rules on part of it and the other part becomes moot, that we're not supposed to on review all of the 12B6?
Your Honor, I don't have that. I don't have a case in mind that says that. I would be happy to research that and provide any sort of information appropriate for that.
Thanks, sir.
Doesn't it appear from the court's order on page 115 of the record that the court specifically mentions in its ruling the statute as a basis for its ruling?
I'm sorry, Your Honor. Would you?
On page, the order to dismiss, the court specifically references 122C-210.1 in its ruling. Does it not?
It does. It does, Your Honor. And I believe, Your Honor, in light of that the court did not. It makes clear that the court did not consider the other issues such as the failure to warn issue when making that ruling. I see that my time is up, and I would respectfully ask the court to request that they reverse the trial court and allow this case to proceed on its merits.
Thank you, Mr. Steinberg. We'll hear from Mr. Cobb.
Thank you, Your Honors, and may it please the court. My name is Barry Cobb, and along with Kelly Brewer, I represent Dr. Brian Robbins, who is a psychiatrist at UNC Wakebrook, a psychiatric facility here in Raleigh. Between January 26th of 2017 and February 28th of 2017, Oliver Funes was an inpatient at Wakebrook. On February 28th of 2017, Dr. Robbins and the team at Wakebrook determined that Oliver Funes was stable and appropriate for discharge. He was discharged with a plan to continue his treatment as an outpatient. He was discharged with 14 days of oral medication that he would be able to take at home, and with prescriptions for outpatient therapy to continue once that 14-day period was up.
Is this are these allegations contained in the complaint?
Yes, sir, Your Honor.
Okay, that's fine.
The complaint does allege that oral medications were given. The argument that the plaintiff has made is that long-acting injections should have been given instead of the oral medication, but they acknowledge in the complaint that the oral medications were in fact prescribed.
And let me ask you a question. Are we under the old 122C? Is that correct?
Yes, sir, Your Honor. I believe we are.
I'm confused about just the ordinary negligence claim. Under the old 122, don't you have to prove, isn't the burden on the defendant just to survive? Don't you have to prove that you're entitled to qualified immunity to begin with? Don't you have to prove that, or at least allege and get the summary judgment that you follow the requisite procedures and exercise professional judgment simply just to survive the ordinary negligence claim?
I don't believe so, Your Honor. And the reason I don't think so, I certainly see how that argument can be made from the language of the statute itself, because the language of the statute itself doesn't talk about gross negligence in those words. It instead talks about the issue of professional judgment, practice, and standards. But it has been consistently interpreted by both North Carolina courts and federal courts interpreting it to require a showing of gross negligence and pleading gross negligence as a basis for getting past this immunity. I would also contend, Your Honor, that the very nature of a qualified immunity is it is an immunity from being sued. It is not a defense that is developed later by the defendant based upon all of the facts that come out.
I'm reading the Borlett opinion. I'm reading the Borlett opinion, the bottom of page 534, and we said this immunity does not attach until a defendant, the immunity itself. Gross negligence overcomes immunity, but it says the immunity does not even attach until the defendant shows that he or she followed the requisite procedures and that the decision as to how to treat the patient was an exercise of professional judgment. So, I mean, it seems like it's placing this on the defendant, but I guess the plaintiff could allege that the defendant did follow the requisite procedures, but if they don't allege that, isn't it on the defendant to show that, to make sure the immunity attaches to begin with?
I would respond to that in two ways, Your Honor. First of all, the citation there in Morulette for that is to the Snyder case. And the holding in the Snyder case was that there was not sufficient evidence in the record to determine as a matter of law that the immunity should attach. And as a result of there not being sufficient evidence in the record to determine as a matter of law that the immunity should attach, the case was not properly before the Court of Appeals for decision because it was an interlocutory order.
Okay, so what in the complaint has been alleged that shows that the immunity should attach? I guess that's what I'm asking.
So, Your Honor, I would contend that what has been alleged in the complaint is that that this is a physician at a facility who provided management to a client based upon the management, supervision, treatment, or release. All of the prerequisites for this statute to apply are applied. And what the statute says is that no physician under those circumstances is civilly liable where they have used professional judgment standards in practice. The plaintiff has not alleged that those professional judgment standards in practice were not used in this case.
Okay.
So it's an immunity, Your Honor, and it's clear that it's immunity. The statute specifically says this immunity is in addition to other legal immunity from liability.
Isn't your argument shifting the burden back to the plaintiff from what Borlett said it was your burden?
Well, I would contend, Your Honor, that the plaintiff is attempting to shift the burden to us where the statute says that we have an immunity. An immunity is not a defense. An immunity is an immunity from suit to be able to have that suit brought against you in the first place.
But our court says the defendant must show this. It does not attach until the defendant shows. You have to show that you're entitled to the immunity, I guess. And I guess, I mean, I can see an argument that they allege that all this was done in the exercise, maybe the bad exercise or whatever of Dr. Rob, I mean, his professional judgment. I'm just trying to understand. It just says the defendant shows that he or she has followed the requisite procedures and that the decision was an exercise of professional judgment. So I'm just trying to see where that has been alleged in the complaint such that you don't have to show it because it's been shown in the complaint.
Certainly, Your Honor, taking the complaint as a whole, there is discussion of the fact that Dr. Robbins, there's discussion of the fact that Dr. Robbins and the rest of the team determined that they believe that discharge was appropriate and that this patient was stable. And that is alleged at paragraph 118. Dr. Robbins stated that the treatment team had determined that Oliver was stable and appropriate for discharge. They've then argued that Oliver was not stable and appropriate for discharge. That's a question of whether he was right or wrong about the determination that he made, but they've certainly said that he stated in his medical record that Oliver was appropriate for discharge, and the failure to allege that was a outside the exercise of judgment standards in practice, we contend is where the plaintiff has failed to set out what they need to set out in order to avoid the application of this immunity.
I would agree with that. I'm trying to figure out what the first part of that says, that you've got to show that he was exercised professional judgment and followed, quote, the requisite procedures. I mean, are you not following the requisite procedures if you don't look at the chart on the day of discharge? I don't know. Which would take you outside the meeting. I'm just trying to understand what that language means. I don't really.
I would argue, Your Honor, that at a minimum, in order to get past this immunity, the plaintiff has to allege that there has been a failure to do the things that are set forth in this statute. And these cases, the Borulette case and the Snyder case before it, were both summary judgment cases where the court was attempting to sort of weigh the contending allegations of the parties about whether the evidence in the record showed that you did or didn't exercise that professional judgment standards in practice. Here, the plaintiff hasn't even alleged that there was a breach of those professional judgment standards in practice. And that is fatal to the complaint, we contend. That was
Well, now, isn't it a fact that he did allege that your client was grossly negligent in doing various things? Are you contending that he's got to allege that he was willful, wanton, and all of those things that was in the case that you cited in your brief? That he's got to allege willful and wantonness, or is gross negligence enough?
Your Honor, saying gross negligence by itself, I would contend, is not enough.
Is that not a term of art in our gross negligence? And it's a defined term, is it not?
It is a term of art and a defined term, but you also have to make factual allegations to support that conclusory allegation that there's been gross negligence. And that comes from the Driver versus Burlington Aviation case. That's a case where, like this case, there was a 12B6 motion. There is an allegation, according to the opinion in the complaint, of gross negligence, but the facts that are alleged simply do not support a finding of gross negligence or do not support believing that there's an allegation of gross negligence as gross negligence has been defined by our courts. And I would contend that this is exactly the same situation here, Your Honor. As you all have talked about already, gross negligence is defined as wanton conduct done with conscious or reckless disregard for the rights and safety of others. That's from Toomer versus Garrett. Yancey versus Lee goes on to say, an act or conduct rises to the level of gross negligence when the act is done purposely and with knowledge that such act is a breach of the duty to others, i.e. a conscious disregard of the safety of others. An act or conduct moves beyond the realm of negligence when the injury or damage itself is intentional. So in order to allege gross negligence and allege facts that support gross negligence, you have to allege not only the words gross negligence, but also that something was done purposely and with knowledge that such act was a breach or duty to others, a conscious disregard.
Would H survive that? Because they allege that Oliver was discharged when it was apparent, I assume, to Dr. Robbins, it was apparent that he was not mentally stable. So they're alleging that it was apparent to Dr. Robbins that he was not mentally stable, but they discharged him anyway. I'm not saying that's what happened, but why wouldn't that allegation be enough to be gross negligence?
Because it's also alleged in paragraph 118 that Dr. Robbins had stated that the treatment team had determined that Oliver was stable and appropriate for discharge. That's an allegation that's earlier in the complaint that's incorporated by reference into this cause of action. So,
and they did so when it was apparent to him that he was not mentally stable. I'm just reading the complaint as a whole.
I understand, and my argument, Your Honor, is that's the one allegation where they say that Dr. Robbins knew something, as opposed to failed to know something or failed to recognize something that was significant.
Is that enough?
But I would say not. It's also been argued. It's also been set forth elsewhere in the complaint that he believed that Oliver was stable and appropriate for discharge in paragraph 118 of the complaint. In paragraph 118, 119, and 120 talk about Dr. Robbins analyzing aggravating and mitigating factors about dangerousness. The plaintiff contends that he did that wrong, that he analyzed those issues inappropriately, but that's not the same thing as intentional and conscious disregard of the safety of other people. So reading the complaint as a whole, I would contend, Your Honor, that it was apparent by itself when wrapped in with all of the other allegations that are in the complaint is not sufficient for the plaintiff to show that there was a conscious disregard.
Well, they also allege in paragraph I that he sent him home with medication knowing that he had a history of refusing to take it. Do they not?
It does say that it does allege in paragraph 142I that Oliver should have gotten long-acting antipsychotic medications. Again, though, paragraph 127 of the complaint makes it clear that Dr. Robbins did provide a 14-day supply of oral antipsychotic medications and prescriptions for those medications to continue after that 14-day period.
Well, and he provided that knowing that he had a history, they've alleged, and we're at the pleading stage here, so obviously we don't know would be found to be true at the end, but when they've alleged that he did that, providing that he knew that he had a history of not taking it when he sent him home with it, didn't they not?
That they have alleged.
And they've alleged that that's grossly negligent.
They have alleged that in a section of the complaint that is entitled gross negligence, Your Honor. But is that?
And what it said, it doesn't just the section that says that. It says he was grossly negligent in that he did these things, and I is one of those things that they say he did that was grossly negligent.
That's true, Your Honor. However, again, taking the complaint as a whole, taking the other paragraphs in the complaint that are incorporated, what we're comparing is not sending the patient home with absolutely no medicine versus sending the patient home with medicine. We're comparing sending the patient home with an oral medication where there is some history of not complying, but where the patient has been treated for a month, against sending the patient home with medication, versus sending the patient home with an injectable, longer acting medication. That's a matter of judgment, I would contend, Your Honor, and is where the statute comes into play to say the exercise of judgment, even if that judgment is wrong, gets you over this hump. And the plaintiff hasn't alleged the kind of gross negligence that would overcome the immunity provided for in the statute.
Well, isn't the language of this statute very similar to what we have with the stand your ground law and the immunity there that makes someone immune from criminal and civil liability? And our courts have interpreted that for the last 9 years as being a defense that the defendant's entitled to. Why should we interpret this statute any differently from this just being a defense that you're entitled to?
Well, because it talks in the language of the statute itself about it being an immunity.
So do those statutes. So do 1451.2 and 1451.3.
So I can't say I'm as familiar with the stand your ground statute and the cases interpreting those as I am with this area of the law, Your Honor. But my argument here would be that because this is an immunity, because the courts have made it clear that, I mean, the quotes are pretty specific about this. For example, in the Cantrell versus U.S. case, Judge Boyle said, absent an allegation of gross negligence or intentional negligence, the plaintiff's claims are precluded by statutory immunity.
But we're not bound by Judge Boyle's opinion, are we?
You're certainly not, Your Honor. But that's part of a series of interpretations by both North Carolina and federal courts that talk about the requirements of pleading and proof to overcome this immunity. In Bourguelet, the court said claims based on ordinary negligence do not overcome statutory immunity pursuant to section 122C210.1. The side court said, we therefore conclude that 122.24, which was the predecessor statute, it was intended to create a qualified immunity for those state employees that it protects, extending only to their ordinary negligent acts. It does not, however, protect a tortfeasor from personal liability for gross negligence and intentional torts.
Sorry, go ahead.
Well, my argument, Your Honor, is we could have a fight later in the case about whether the facts were sufficient as shown to establish this immunity. But if you don't plead it to start with, you've never even put it in issue. If you don't plead that there was not there was a failure to follow judgment standards and practice, then you have failed to even get into court because there's an immunity that attaches, and you have to plead that you get past that immunity in order to even begin the conversation. The plaintiff has failed to do that in this case.
Can you point me to any case outside of the requirement for waiver of sovereign immunity against the state and its subparts where we have ever held that the lack of an immunity must be pled?
Your Honor, I don't know that I can. I guess what I would say about though is this statute started out as a qualified immunity for state employees. This statute began in that context. The legislature decided, the General Assembly decided to expand that qualified immunity beyond state actors to private actors who were involved in this particular type of evaluation, management, treatment, and care. and expanded the immunity beyond what was originally applied. So the state cases, I think, would be the best analog or the place to start, because that's how this statute started.
But we've never held that you had to plead it in order to get around it, have we?
That you've had to plead.
That you waived it in order to get around it?
No, Your Honor, not for this statute.
That's what I mean for this statute.
That's correct. That has not been pled. My contention, though, Your Honor, and I think I've made this clear, I'll move on, but my contention is, if it's going to be an immunity, then it has to be true that you must plead that there has been a breach of judgment standards and practice in order to proceed into discovery, the gathering of the facts, and those kinds of things. Otherwise, it's not an immunity anymore. Otherwise, now it's a defense, and that's not what the legislature intended when they called it an immunity in the statute. So, Your Honor, we contend that Judge Gray's decision in this case should be upheld on three bases. First of all, and I think from the discussion during the course of Mr. Van Steinberg's argument that this is less of a focus for the plaintiffs, but certainly the ordinary negligence claims that the plaintiff has attempted to assert don't get them past this statute based on the way that all of the courts interpreting this statute have interpreted it. They all say that there must be a showing of gross negligence in order to avoid the immunity that's provided for in the statute. And the plaintiff's first cause of action in this case doesn't even attempt to plead gross negligence. So the allegations in that first cause of action, we contend, must be dismissed, were appropriately dismissed, and that dismissal should be upheld in this case. Mr. Van Steinberg, as I understand his argument, suggests that if you have properly pled gross negligence somewhere in the complaint, then other counts of the complaint that don't plead gross negligence should survive anyway. That's certainly not the way that this court and other courts treat various causes of action in complaints. It is not at all uncommon for a court to dismiss one cause of action and allow the rest of the complaint to go forward if one cause of action is legally deficient and the rest of the complaint is not legally deficient. So each one of these claims, we contend, should be considered on its own merits. And the first claim for relief doesn't allege gross negligence anywhere in it, therefore doesn't meet the requirements of getting past the immunity statute, and was appropriately dismissed.
How does that argument mesh with Judge Dillon's question about whether or not your burden with respect to that in order to get there?
Well, Your Honor, I think if we were only looking at the statute itself, then I think things might be a little bit different. But the way that the case law has interpreted this statute, they've made it clear that gross negligence is a requirement in order to get past this statute. And a claim that doesn't even allege gross negligence, we contend, simply doesn't pass muster to get you past the immunity that's provided for in the statute. It doesn't make sense to allow the plaintiff to conduct discovery, to proceed with gathering information, to marshal evidence on a claim that ultimately is futile, because there has to be a showing of gross negligence for it to proceed.
So you're saying if your client was merely negligent but did not follow requisite procedures in an exercise of professional judgment, there's still no claim?
The way that this statute has been interpreted by the courts, I believe that's true, Your Honor. I'm just
reading boilerplate again. This immunity does not attach. There's no statutory immunity. It does not attach until the defendant shows that the doctor followed this whatever, and then it goes on to talk about how that is shown. I mean, and if it does attach, then the only way the plaintiff can win is by showing gross negligence. I'm just misreading the case. It seems like that's what they're saying.
Well, Your Honor, I would contend that, again, if you read Bourulette and you read Snyder, and you look at that, because the citation for that decision or that line in Bourulette is from the Snyder case. And the Snyder case was a summary judgment case. The Snyder case was a case where there was evidence in the record. The Snyder case is a case where there were allegations in the complaint gross negligence and breach of practices, standards, and judgment in the complaint. The facts of those cases don't support the idea that the defendant can only rely on this defense or can only rely on this statute. Can rely on this statute only if the plaintiff has somehow pled that those judgments, practices, and standards were complied with in their complaint. That flips the burden in a way that is not consistent with the burden of proof generally being on the plaintiff, I would contend, and is not consistent with the idea of immunity as being the right not to be sued.
I'm reading the last sentence of Snyder, and it says the plaintiff has offered sufficient evidence to create a question of fact for the jury to decide whether the defendant followed accepted professional judgment within whatever, so that the defendant is not entitled to qualified immunity as a matter of law. So, I mean, it seems like there's a burden on the defendant to show that they're entitled to qualified immunity, and if the plaintiff puts forth some evidence that the doctor did not follow accepted medical treatment, then your ordinary negligence claim would survive. Because
but the plaintiff put forward enough evidence in the Snyder case to get past the immunity as a matter of law and to make the denial of summary judgment an appropriate one for the trial court. That's what the Snyder
you can sue for negligence if the doctor did not follow accepted medical whatever the statute says. You do have a claim, because the only way you get that immunity is if the doctor did follow the accepted medical professional judgment, and then you could only win if you show gross negligence. That's what I'm understanding this case law to say.
But Your Honor, if it is true, as the cases say, that claims based on ordinary negligence do not overcome statutory immunity pursuant to section 122C-210.1, a plaintiff must allege gross or intentional negligence. And that's what Bourulette says.
And then it goes on to say you only get that immunity if you show that you followed the whatever. I mean, and then Snyder says, the court has found, only offers qualified immunity under the statute so long as the requisite procedures were followed in the decision, blah, blah, blah. And in that case, he sued just for ordinary negligence. And they said that you don't get ordinary negligence if you fall within the statute, but you got to show that you fall within the statute, that the doctor did apply the requisite standards or whatever the language is.
But if a claim for ordinary negligence cannot succeed ever, as the Bourulette case says, claims based on ordinary negligence do not overcome the statutory immunity, then why should the court permit those to go forward in a case where gross negligence, or in a claim, in a particular cause of action, where gross negligence is not even pled?
Well, but doesn't the defendant have to show that they're entitled to qualified immunity? And aren't what you're asking us to do is to put the burden on the plaintiff in their pleadings to show they're not entitled to qualified immunity, to prove in their pleadings, not just to allege, but to prove in their pleadings is the standard that you are proposing to us today, as I understand your argument.
I'm certainly not alleging that they have to prove in their pleadings that we're not entitled to qualified immunity. I do believe that they have to plead in their pleadings that we're not entitled to qualified immunity.
And is there any case that's ever said that with respect to this statute?
So there are certainly cases that have talked about the fact that the plaintiff did plead in their complaint that there was a failure to comply with judgment standards and practice. I believe the Snyder case has that.
Snyder and Boyette were both summary judgment cases, were they not?
They were, Your Honor. That's right. And that's because in those cases, the plaintiff had pled what they needed to plead to get past the 12B6 stage. And then there was evidence that was in the record to argue about whether they had gotten over the hump at the summary judgment stage. But first, in order to even get into that conversation, you have to plead what you need to plead in the original complaint. And they had done that in those cases. They have not done that in this case. They haven't pled gross negligence in this cause of action, and they haven't pled that there was and the gross negligence that they have pled in the second cause of action, we contend for the reasons we talked about previously, is not sufficient. I see I'm running close on my time. I do want to get briefly into the question of failure to warn. Failure to warn is clearly decided by the Gregory versus Kilbride case as a cause of action, a claim that's not recognized in North Carolina. This court rejected the Tarasoff reasoning and decided that we don't recognize failure to warn claims in North Carolina. That is sufficiently clear that Mr. Van Steinberg conceded it in his argument at the trial court level, and that can be seen in the record at page 22, line 15, that he conceded that. This is a de novo review. This court has every power and every right to review any of the allegations of the complaint and to make your own decisions about whether you believe those are consistent with North Carolina law and state a claim to which relief can be granted under North Carolina law. So you certainly can determine that failure to warn is not an appropriate cause of action in North Carolina and dismiss those claims.
And I noticed that your brief doesn't hit on our scope of review here with any case citations. Do you have any cases that we should be looking at that would suggest that our scope of review is that broad when the trial court's ruling was so narrow?
I think we certainly talk about in our scope of review, a section of the complaint, that the scope of review for the court is de novo. And in deciding cases de novo from a 12b6 perspective, you all have the power to make a decision to look at the complaint itself and to make a decision based on the complaint and based on the law, whether that complaint or any allegations in that complaint are sufficient to state a claim under North Carolina law. And in this case, they do not. Your Honor, I see that my time is up. Unless anybody has any further questions, I'll stop there.
Thank you for your argument. Rebuttal? Mr. Van Steinberg?
Thank you, Your Honors. Briefly, the defendant he makes an issue of that plaintiff has not pled that the defendant did not follow accepted professional judgment practice and standards. I would disagree with that characterization, especially in light of on page 20 that plaintiff has included, and I believe that's, I don't have the record citement, but it's page 20 of plaintiff's complaint. And it is a 9J certification, and while the plaintiff would contend that this is not a 9J case based on the lack of physician patient relationship between the parties, out of abundance of caution, we did secure a 9J compliance, which is exactly that, a certification that the defendant did not follow the standard of care, which is the accepted professional judgment practice and standards as recognized by the similarly qualified doctor in the same specialty. Further, Your Honor, the defendant pointed to paragraphs 116 through 122 of plaintiff's complaint, and I'd like to clarify that I believe those were represented as what Dr. Robbins believed when he was completing the assessment prior to Oliver's release. I will say, Your Honor, that those are really recitations of what was contained in the records, and that in actuality, plaintiffs would allege that unlike that when Dr. Robbins said that he did contact Oliver's family, that Your Honor, that Dr. Robbins, or that rather that the plaintiff would dispute that, and again, pointing to a disputed fact that should be developed through through discovery, and that would be appropriate for summary judgment, but not for 12b6, and that essentially is what is happening here, Your Honors, that the defendant is making a summary judgment argument too soon. Then both the Snyder case and the Brouillette case were summary judgment cases, and it was appropriate at that point that the Snyder case was determined to not only have that the plaintiff's complaint had sufficiently pled gross negligence to overcome immunity, but that he had developed the facts through discovery to show that the professional judgment practice and standards were not followed. Finally, Your Honor, I would just briefly touch again on the what I would contend is the faulty logic based on the Brouillette case, that just because you can't only plead ordinary negligence and survive a motion to dismiss does not mean that you can't have ordinary negligence claims along with gross negligence. I don't believe that the defendant has shown this court a case that says you can't have both, and only the Brouillette case says that you can't have just one.
I do have one question. As I read it, you've made a claim for negligence. You would win even if you don't show gross negligence, if you can show that Dr. Robbins' action fell outside the statute somehow. You can win on a gross negligence claim even if it falls within it. But I don't, and the trial court dismissed both claims 12b6. And we've been talking about whether or not it's just on the ordinary negligence claim, we've been talking about whether or not it's the defendant's burden to show that they fall within the statute. But I'll have to say, I can't find anywhere in your brief where you've argued that the trial court erred in just dismissing the ordinary negligence claim. I mean, I'm just skimming it, but your argument seems to be totally based on the gross negligence claim. Am I right? Are you basically waiving your negligence claim as far as, your ordinary negligence? Because I don't see any argument that you've made.
Your Honor, I would contend that that both claims should have survived the 12b6, and that the trial court dismissed the whole complaint, but that was based on the belief that there was a lack of gross negligence pled in the complaint itself. And I would agree that the plaintiff can survive on simply a showing of that the defendant did not follow the accepted judgment practice and standards. And I understand it did not raise that in plaintiff's brief based on the language of the trial court's order, but did address that in the plaintiff's reply brief as to why the ordinary negligence claim should survive.
And also, Mr. Steinberg, in looking at your brief, looks like your opening brief, top of 6 in your argument, you do say trial court erred by dismissing plaintiff's claims, plural, there for failing to plead gross negligence. Is there any other place where you use the plural outside of just your header?
Your Honor, I'm not aware. There may be in the plaintiff's final brief.
Thank you, sir.
Yes, sir. Thank you, Your Honor.
Thank you guys for your arguments. We will take this under advisement, and we can adjourn court. Mr. Sewell.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you, Your Honor.